আচ্ছা, আমাদের যে 26,000 চাকরি বাতিল মামলার রিভিউ হিয়ারিং, রিভিউ পিটিশন দাখিল করা হয়েছিল। তো আজ তো আর কিছুক্ষণের মধ্যে শুরু হতে চলেছে। আপনারা অবশ্যই ভিডিওটাকে শেয়ার করে দেবেন। এবং আজকে আমরা কয়েকটি গুরুত্বপূর্ণ বিষয় জানতে পারবো। প্রথম কথা, 26,000 চাকরি বাতিল, তারপর আপনার ডিএ মামলার চূড়ান্ত সিদ্ধান্ত আসতে পারে। আর আপনার এদিকে ওবিসি সংক্রান্ত গুরুত্বপূর্ণ মামলাটি কিন্তু সুপ্রিম কোর্টে উঠবে আজ। আচ্ছা, এখন তো লাইভ যে এখন পর্যন্ত শুরু হয়নি। তো আপনাদের যদি কোনো প্রশ্ন থাকে, ঠিক আছে, চাকরি সম্বন্ধিত কোনো প্রশ্ন বা কোনো কোয়ারি, সেটা রিলেটেড কোনো কোশ্চেন, এডুকেশনাল যে কোনো রিলেটেড কোশ্চেন করতে পারেন। আছি আপনাদের সঙ্গে কিছু সময় লাইভে, তো অবশ্যই উত্তর দেবো। ভিডিওটাকে অবশ্যই শেয়ার করবেন। চাকরি সম্বন্ধিত যে কোনো কোশ্চেন থাকলে অবশ্যই কমেন্ট বক্সে জানাতে পারেন, এবং আমাদের চ্যানেল নতুন হলে অবশ্যই সাবস্ক্রাইব করে বেল আইকনটি প্রেস করে রাখবেন। আজকে আমরা কয়েকটি গুরুত্বপূর্ণ বিষয় জানতে পারবো। প্রথমত বললাম আপনাদের যেটা হচ্ছে 26,000 চাকরি বাতিল মামলার রিভিউ হিয়ারিং হবে আজ। কি হয় দেখা যাক, এদের আর একটা সুযোগ জীবনদান পায় কি না। তো আপনাদের কি মতামত অবশ্যই জানাবেন কমেন্ট বক্সে। আর এছাড়াও আপনাদের ডিএ মামলার আজকে চূড়ান্ত শুনানি আসতে পারে, এবং ওবিসি সংক্রান্ত যে লিস্ট সেটা নিয়েও কিন্তু আজকে কিছু একটা আসবে। আর আজকে আপনার কিন্তু ডিএ মামলার ভবিষ্যৎ কিন্তু আজকে একটা চূড়ান্ত সিদ্ধান্ত আসতে পারে। আমরা ভারতের সমস্ত রাজ্যের সরকারি কর্মীদের ভবিষ্যৎ জড়িয়ে আছে কিন্তু আজকের এই বিচার ব্যবস্থার দিকে। আজকে কি হয়, তো দেশের সর্বোচ্চ আদালতের প্রতি কিন্তু সাধারণ মানুষের বিশ্বাস আছে। এখন দেখা যাক কি হয়। আপনাদের প্রথমেই বলি, আজকে যে ডিএ মামলার চূড়ান্ত শুনানি হওয়ার সম্ভাবনা রয়েছে, তো সেখানে ডিএ মামলার বিষয়ে যদি বলতে চাই তাহলে কিন্তু সুপ্রিম কোর্টের কিন্তু একটা বড় পর্যবেক্ষণ। কি বলুন তো, ডিএতে আপনার 25% মিটিয়ে দিতে রাজ্যকে কিন্তু আগেই নির্দেশ দিয়েছিল শীর্ষ আদালত, আপনারা জানেন অনেকেই। তো সে বিষয়টা 6 সপ্তাহ সময় দিয়েছিল, কিন্তু ওই সময়সীমার মধ্যে রাজ্য টাকা দিতে পারেনি, বরং আরও সময় চাইল রাজ্য। আর এদিকে শুনানির শুরুতেই কিন্তু রাজ্য সরকার আইনজীবী সওয়াল করেছিল যে আরও কিছু সময় চান। ঠিক আছে, তো সেই মামলার শুনানি কিন্তু আজ হতে চলেছে। আজ কিন্তু একটা বড় দিন। তো আজকে কি হবে কি না হবে আমরা কিন্তু ডিটেলস সরাসরি লাইভে দেখে নেব। ঠিক আছে, আমরা এটা তো সব চলছে, ওটা শুরু হলে কিন্তু আমরা ওখানে চলে যাব। তো এর পাশাপাশি আপনাদের একটা ব্রেকিং নিউজ দিয়ে রাখি টিচার রিক্রুটমেন্ট কেস ব্যাপারে। বিষয়টা কি দেখুন তো, কলকাতা হাইকোর্টে একটি শিক্ষক নিয়োগের মামলা খারিজ হয়ে গেল। কলকাতা হাইকোর্টে আরও একটি শিক্ষক নিয়োগের মামলা খারিজ হয়ে গেল। বিচারপতি সৌগত ভট্টাচার্যের বেঞ্চে এই মামলাটি খারিজ হয়, যা 2009 সালে উত্তর 24 পরগনা জেলার প্রাথমিক শিক্ষক নিয়োগ প্রক্রিয়ায় সঙ্গে সম্পর্কিত ছিল। এই রায়ের ফলে আবারও একবার নিয়োগ প্রক্রিয়ার স্বচ্ছতা এবং আইনি জটিলতা নিয়ে প্রশ্ন উঠেছে। মামলাটি কেন খারিজ করা হলো, তার পিছনে আদালতের কি যুক্তি ছিল সেটা বিস্তারিত বলছি। দেখুন, মামলার প্রেক্ষাপটটা কী ছিল। মৌসুমী ঘোষ সহ বেশ কয়েকজন চাকরি প্রার্থীরা মামলাটি দায়ের করেছিল। তাদের মূল অভিযোগ যে ছিল যে 2009 সালের প্রাথমিক শিক্ষক নিয়োগের সময় তারা যোগ্য, তারা মেধাবী হওয়া সত্ত্বেও তারা নিয়োগপত্র পাননি। তাদের চেয়ে কম নম্বর পাওয়া প্রার্থীরা চাকরি পেয়েছেন বলে তাদের দাবি ছিল। মামলাকারীদের আরও দাবি ছিল যে উত্তর 24 পরগনা জেলার এখনও শূন্য পদ রয়েছে এবং সেই পদগুলি তাদের নিয়োগ করা হোক। আদালত পর্যবেক্ষণ এবং রায়। আদালত এই মামলাটি শোনার পর কয়েকটি গুরুত্বপূর্ণ বিষয় তুলে ধরে, যা ভিত্তিতে মামলাটি কিন্তু খারিজ করে দেওয়া হয়। আচ্ছা, কি বিষয় দেখুন, এখানে আদালত উল্লেখ করে যে বিচারপতি রাজশেখর মান্তা 2022 সালের 25শে এপ্রিল একটি রায় দিয়েছিল, যেটা হচ্ছে কাকলি মণ্ডল বনাম পশ্চিমবঙ্গ রাজ্য সরকার মামলা। সেই রায়ে বলেছিল যে নির্দিষ্ট তারিখের মধ্যে যারা মামলা দায়ের করেছিলেন শুধুমাত্র তাদেরই নিয়োগের জন্য বিবেচনা করা হবে। সেই সিদ্ধান্ত ডিভিশন বেঞ্চ এমনকি সুপ্রিম কোর্টে বহাল রেখেছিল। বর্তমান মামলাটি 24 সালে 19 এপ্রিল দায়ের করা হয়েছিল, যা নির্ধারিত সময়ের অনেক পরে। এই বিলম্বের কারণে আদালত আবেদনকারীর আবেদন শুনতে রাজি হয়নি। বোঝা গেল বিষয়টা? তো মামলা খারিজের দ্বিতীয় এবং সর্বশেষ সবচেয়ে গুরুত্বপূর্ণ কারণ হলো নিয়োগ প্যানেলের মেয়াদ উত্তীর্ণ হয়ে যাওয়া। আর 2024 সাল 2009 সালে নিয়োগ প্রক্রিয়া প্যানেলটি 2021 সালে 10ই ফেব্রুয়ারি প্রকাশিত হয়েছিল। হ্যাঁ, তো বিষয়টা আশা করি আপনাদের কাছে ক্লিয়ার হলো। তো যেহেতু টাইম অতিক্রান্ত হয়ে গেছে নিয়োগ এই জন্য আর কি ওটা খারিজ হয়ে গেছে। তো 2009 সাল নিয়ে কিন্তু আর কেউ নিয়োগ চাইতে পারবে না সরকারের কাছে বা কোর্টের কাছে। আজকে কিন্তু ডিএ মামলার চূড়ান্ত শুনানি হতে পারে। হ্যাঁ, ডিএ মামলার চূড়ান্ত শুনানি হতে পারে। আমরা ডিএ মামলা শুরু হলেই কিন্তু সেখানে লাইভে চলে যাব। আজকে ডিএ মামলার চূড়ান্ত শুনানি হতে পারে। এবং ডিএ মামলা কি চূড়ান্ত শুনানি হয় আমি কিন্তু আপনাদের এখানেই আপডেট জানিয়ে দেবো। এই 26,000 চাকরি বাতিল মামলার যে লাইভ হিয়ারিং চলছে এখানে একটু বাদে শুরু হবে, এখানে কিন্তু আপনাদের আমি লাইভ জানিয়ে দেবো যে কি হতে চলেছে কি না হতে চলেছে। তন্ময় কি বলছো? ভিডিওটাকে একটু গ্রুপে শেয়ার করে দাও। ভিডিওটাকে একটু গ্রুপে শেয়ার করে দাও। ভিডিওটাকে একটু সমস্ত গ্রুপে শেয়ার করে দাও।
Yes, I'm Similar fields stand allowed.
Yes.
Post has been granted. You are asked to execute a gift deed within the 30th of this month or for the 15th of next.
The rest of the cases.
Apartments, you are giving the car sheds also. Parking places. Parking places.
Parking place, parking.
Two parking places, and what about the two cars also? You said you don't want the cars. That's what.
No, it's been sold in scrap.
Scrap.
Sold.
Okay. Buy a new BMW phone.
A lot of the criminal cases have been quashed.
Yes, yes, yes.
Yes,
yes.
We are not only cautious criminal proceedings, but we also injected both the parties not to initiate any
Any case.
criminal or civil proceeding against each other in future.
Each other. Highly
Most of
blessed.
life.
Highly blessed. Highly.
Any date, there is no any date showing, my lord. It's a very short matter.
After presidential reference.
Great.
My lord, I am requesting for any shorter date in this matter, my lord. Pleadings are complete, my lord.
What is the matter about?
It is a matter between the husband and wife, and there are the allegations. We have complied all the conditions, whatever have been, assigned by the trial court or by the Honorable High Court. We arrived between the parties. The settlement was there. We have complied. She has received 15 lakh rupee as alimony. Thereafter, we have been directed to pay 50 to 60,000 per year. We are paying more than that, my lord.
No, so you are praying for divorce.
No, divorce has been granted.
Then what do you want?
What they are saying that this whatever condition has been mentioned in the settlement deed, we are not complied with. That's why they have approached the Honorable High Court in contempt or discharge. They were saying no, they are complied. They are complying. all the condition, whatever.
Go up, take out.
I'm grateful, my lord.
Monday, Friday.
I'm grateful.
804, Your Lordship, the petitioner is in custody for more than 12 years. Your Lordship, no date has been shown in the case status of the matter.
Monday, Friday.
And for the
So-
same, yes.
Last occasion, Your Lordship, direct,
We'll keep it on some Monday, Friday.
grateful.
We have filed our counter.
Please note in 805 notes, I'm humbly requesting for a date.
Not to be deleted.
Not, it was
It's
tentative.
already listed on 12th of August, so not to be deleted.
I'm so grateful, not so good.
Not to be deleted.
Your Lordship, the matter is coming up for 26th.
Not to be deleted.
Your Lordship, my humble request, the matter shall not be deleted.
That's what we have said, madam.
Your Lordship.
Not to be deleted.
Yes, ma'am.
Not to be deleted. Not to be deleted.
But it is not in the list, my lord.
Huh?
Not in the list, my lord. My idea is not.
Listed on 19th of August.
Well, I'm seeking liberty to mention a matter.
But could it be a little early, Milord? It's, Milord, this 26th August.
After the presidential debate.
26th August also fine.
Where it is listed, the
Very well. Not to be deleted. I'm so.
Milords, the Lordship's kind permission, Milords, an unlisted mentioning because they can't go through the mentioning process. I have filed a fresh civil appeal under section 62 of the IBC, a statutory appeal. There is no impugned order in that. The reason being, Milords, after the judgment was reserved as per the NCLT rules, we wanted to bring on record certain documents, statutory record, which was some rules and bylaws, which is necessary for the adjudication of that appeal. Unfortunately, as per the rules goes, if you don't, if the mentioning is not allowed, it can't be listed. We made a mention before the honorable bench, the bench declined. So once it is declined, there is no record of proceeding and there is no order. So therefore, when we file a civil appeal,
unless there is judgment, then how can we enter?
so Milord, there is a statement by the advocate on record to that made a mention date and that mentioning has been disallowed because of which that additional documents can't be placed.
Challenge all this along with the main order, if it goes against you.
Because Milord, it's not a part of the record at all. So Milord, I was only requesting for listening.
You should have placed it before you, the matter was closed for
Milord, we were remiss. Milord, that is a fault of.
Or you should have sort of leave at the stage of, when the matter was closed.
Your Lordships are right, Milord. We should have.
Challenge is not when the main judgment is.
Milord, the statutory rule was just left out. Milord, we could not.
Sorry, Ms. Purnell.
May I mention?
Let it start from one way.
Lordship, may I mention
Yes,
one?
Ladies first, Milord.
I'm deeply thankful. Well, I'm seeking an unlisted mentioning.
Yes, yes, jump, ladies. Yes, well, let it start from here.
Lordship, may I mention one fresh criminal matter? This is related to 2021 Ayush NEET fake admission, in which this accused is in jail since 2022.
Okay,
And others 14 accused.
after 2 weeks, yes.
Lordship, this matter, same.
We'll keep it on some Monday or Friday, madam.
Lordship, Justice Dhulia has heard this similar matter, so kindly list this
Why
matter.
do you want to burden him now?
Lordship,
There's,
Lordship, 14 co-accused were released.
yes, but then
23.
why do you apprehend this order would be followed by other judges also?
Lordship, he is suffering with a.
Item 35 of today's list, it's air pollution matter. Lord, the state of Delhi has filed, Lord, NCT of Delhi has filed an application, Lord, with regard to the vehicles, Lord, which could not be listed last time, this time also not listed. Lord, kindly get it, Lord, kindly list it on some date, Lord, so that your lordships can read it and, Lord, we can address, Lord. Maybe tomorrow.
My lord, sir.
I want to mention the similar issue.
Wait, tomorrow.
Maybe tomorrow, subject to your lordship's convenience tomorrow.
Tomorrow, I think we have kept those green bench matters, so we don't know whether we'll have time or not.
But this would be a fresh matter, Lord, if your lordships, Lord, can consider.
My lords, I pulled out certain aspects, certain provisions of the Wildlife Protection Act and the FRA, which we want to assist my lords on.
Okay.
Well,
My lords, may I mention, it's a transfer petition, my lords, a matter arising out of a matrimonial dispute, turning to be a check bounce matter which is filed in Ahmedabad. My lords, I am for the wife. Wife is living in Noida. The husband's
Okay.
family is also living in Noida.
2 weeks, yes.
My lords, it's listed on 8th of August in Ahmedabad, my lords. My predicament is that, my lords, I live
It
in.
can't be before that, yes. Monday, yes.
Faithful, my lords.
With permission, may I mention, the matter was to be listed today. It came up on the last Tuesday also, but due to unfortunate situation, my lord, board was heavy, it could not come, my lord.
This may be listed in some future date, my lord.
Well, as I'm concerned for a medical college in Bihar, I'm concerned for a medical college in Bihar. We are aggrieved by the National Medical Commission's notification saying we have to charge 50% fee at government rates out of our total capacity. We have already filed a writ petition. For the past 2 years, the state of Bihar has expressly kept the implementation on stay, but as of 29th of July, 4 days ago, they have started admission process. I'm going to be highly aggrieved by the process.
Monday.
There is no Justice Oak and Justice Bhuyan have already heard the matter. We are seeking implement and directions.
I will assign the bench.
I'm deeply MLS could be please be list this must Monday because the admission process is ongoing and today the merit list will come out.
I already said Monday.
I'm obliged, miss. Thank you.
Yes.
Yes, sir. Today at item number 35, the old vehicle cars matter is listed and we have a similar issue. So
The learned solicitor mentioned it, we are keeping it.
yes, sir.
Yes, Mr. Shankar Narayan.
So, I just want you to request that our matter should also be taken along with that.
We already said yes.
Okay.
So it's in the Kashmir Constitution Bench matter with reference to the state restoration issue. There's an application. The date is showing as 8th August 25. Will your lordships not delete it from that day? That's the only request. I'm grateful.
Lord, may I mention item 32 in the today's list, Lord? It is regarding recognition of a college pharmacy council, Lord. It is covered by a lordship judgment, but in this sequence, it is at the end, Lord. My request is, Lord, last week also did not reach. It may be taken up at some point of time today, my Lord.
We already kept 2 matters high on the board. One is regarding Telangana admission, and other one regarding those environmental issues.
And thereafter, can it be taken, my Lord? That's all I'm requesting because it's covered by a judgment of your lordship's court.
Who's the other side?
Is Mr. State of Assam, my Lord, is the, I will inform him, Lord.
You will inform them.
I'll inform him. Please,
I will take it up.
Yes, I'm grateful to my Lord.
Your Lordship, we're seeking to mention, Mr. Shankar Narayan has mentioned the matter last week. This is that Karnataka mining and environment matter. Your Lordship, the problem appears to be there's a 3-judge bench constitution issue here. Your Lordship is already taking the TN Godavar.
In the 3 judges bench is constituted.
Your Lordship is already taking the TN Godavarman and the MC.
You are taking in combination of 2. And then when the 3rd judge is available.
Your Lordship, these applications were filed in last August.
We are aware, but there should be a 3-judge bench to hear that matter. We can't constitute for one matter.
Your Lordship, there are multiple applications in this.
Maybe, yes, we will consider it as and when.
Your Lordship, at the earliest convenience.
Yes, next matter.
Kindly pass over. Dr. Singhvi is leading this matter.
To take instructions.
Lordship, may I mention him? Dr. Singhvi, Lordship, I am appearing as an in-person in Suomoto 2 of 24. Lordship, it was directed by 10/12/2024 by the court to send all the intervening application to the NTF committee. And the NTF committee will, but NTF committee has not replied.
What do you want now?
Lordship, urgent listing of the matter so that I may place my recommendation to the Lordship.
You can start. He's coming. But on the last occasion, your lordship directed the state to take instructions because whether the interim arrangement could continue this year also, and then the matter could be heard. Otherwise,
we are very clear, my lords, that we need to argue this matter.
Yes, okay.
So I'll just
by of an interim order.
Yes.
We direct that the state shall permit the students who are otherwise domiciled in the state of Maharashtra, sorry, or the state of Telangana, but who have not passed the 12th examination from the state of Telangana, be considered for admission to the only for MBBS.
My lords, I'm sorry.
Need UG.
I'm sorry. If your lordship are passing the order, let me just argue it.
Yes,
I'll just argue it because we believe that there's a square case as to why last year, your lordship will recall, we had made a concession.
You argue,
yes.
You proceed on the merits for the matter.
Yeah, only on the merits. Only on the merits.
I must tell you, Gopal, just before lordship had passed in here.
Let him address now.
Yes, correct.
Can't object to the other party hearing.
What I'm saying is that imprimatur is not.
You can't object to the other side wanting to argue the matter.
Yes.
Absolutely.
Wait, please, my lord. Well, it's the,
How many petitions are there by the state?
There's Telangana and the university are both petitioners in the same petition. There's one university for Telangana for medical, which is the university I represent.
So it's a common petition. So you're asking if there's one common petition, only one petition, when only one council are arguing.
multiple petitions.
By the states.
There's a connected item as well. So Dr. Singhvi is appearing for the state, I'm appearing for the university. We have overlapping interests.
That's all that I wanted to say before. Was that last time I made a concession on the.
So you argue on merits.
Very well. Now, well, the rule is at 347, relevant at 348. May I just explain to your lordship the context? Malus, today, a domicile rule is made so that the people who need it the most in the proximity geographical get it. Now, take for example, Malus, the Telugu speaking diaspora. The Telugu speaking diaspora.
We are only concerned if a student has passed 10th in that state.
Yes.
He is born in that state.
Yeah.
He is domiciled in that state.
Yes.
But for some reason, he goes and passes 11th and 12th in some other state. So you see, many of the students from throughout the country, they go to quota for 11th and 12th, so that they are specialized for those JEE examination and all that.
Yes.
So what happens to them?
Now, may I explain?
Merely because they don't
Just consider the flip side also. My local area is the whole of Telangana. I have not made narrow local areas. That's the kind of thing a lordship frowns upon. Let me give lordship the concept. Then I understand what my lord is saying. Why it's not unreasonable. Now let's take Telangana as local area. Your lordship has given one problem. I appreciate that. So look at the flip side. The Telugu speaking diaspora is vast. I'm giving an actual example. They are not only, of course, in Telangana, but in India and NRIs abroad.
Yes. Now, you will find them in every state of the United States.
It's probably the second or third largest diaspora, and they're doing very well, and we are proud of that. Now, nevertheless, when their children seek admission to these places, they are actually displacing the local area people.
They will come in an NRI quota. They will not come in the regular quota.
No. They are all.
But you argue on the merits. How the judgment is wrong?
Lordship, the rationale behind the rule.
Yes.
It's not NRI quota is separate. That nobody is disputing. They are people we are saying are per se not eligible to come in the local area because they are nothing to do with the local area in India. Now, there may be some cases. Now, once you accept that the domicile rule has got some reasonableness, then the state has to make a cutoff. The state made a cutoff of 4 years. Now, that cutoff, every cutoff is arbitrary. My lord is example. First question, there are two separate questions. Question one, can the state in the interest of its local students make a rule? Domicile. Second, if it can, then the nature of that cutoff. Now, the nature of that cutoff, suppose I made 3 years, it will not become valid. If I made 5 years, it won't become invalid. My lord knows the principle, all lines drawn are arbitrary. So what the state has done is twofold. One, it has said that people in my state must have some domicile preferential approach. That's the first point. And your lordship has appealed it from Pradeep Jain onwards. Second, once I say that my domiciliaries will have some preference, then I necessarily have to have a cutoff. Now, state in its wisdom chose 4 years. I understand my lords, fellows, 2-year example, etc. But fellows, the state has to have a line. That line, fellows, can't really be second guessed because it's a policy decision. That is the overall rationale behind it. Now just see the rule. The relevant rule is 348. At 348, same page, different page. Which fellows the state has taken care, unlike other matters, to define the local area and to give some specificity. Come from 347 fellows. So keep at the backdrop this rationale. After that, come to 371D.
We are at 348.
347 starts, section so and so. Now let us see 348. On expiry of the tenure provided in 95 of the Andhra Pradesh Act, the government, after careful examination, decided to amend the Telangana medical and dental admissions rules of 2017. Then, well, in exercise of powers, in bottom of the page, well, in Rule 3A, a candidate for admission into undergraduate courses under competent authority should be Indian national person, etc. 4 categories.
Indian national person, person of Indian origin,
overseas citizen, and shall fulfill the following provisions. If the candidate has studied in education institution in a local area for a period of not less than 4 consecutive academic years. I will ask your lordship to keep aside this 3, 4, 5. There will be some arbitrariness in any line. But consider the basic object. Is that correct or not? Your lordship will cite that case of 7 years, the lordship will upheld. 7 years. I'll come to that. Where during the whole of any part of any consecutive academic year ending in which he appeared, or as his case may be, first appeared for the relevant qualifying examination, he has not studied in any education institution. If he has resided in that local, well, there are some typos here, I'm very sorry. Then 4 years immediately preceding the date of commencement of the relevant qualifying examination. Local area herein means the state of Telangana. This is a point your lordship always keeps in mind. Suppose I said local area means the district of Gurgaon. Local area means the district of
reservation is not permissible. That's the federal law.
Region. It means the west of Delhi, the whole of the left half of Delhi, not the right half. I am giving lots of examples, concepts.
Yes, that's only impermissible. It has been held in so many cases.
So all Telangana people can move around so long as they are
within Telangana.
Yes. But small particularized examples, if necessary, according to him, it's covered.
So therefore, we are
even tweak it further for these cases. I have no problem. I can give a lordship assurance. These are very minor, focused examples which are necessary.
So these are not only minor. A person who is a resident of Telangana, who is domicile in Telangana, but even if his parents find that if he is sent to 11th, 12th to a particular institution, say in Delhi or in Madhya Pradesh or Maharashtra, he will have a better chances of appearing in a NEET. And only for 2 years he goes out of Telangana. He will stand excluded.
Well, I am not making any general concession, but for government servants on deputation, I am told they are covered, but we can.
Therefore, you tell us how the judgment is wrong. That's all.
Therefore, I am coming to the law. Straight away I am coming to the law.
Rule. You can't, and we have to read the rule as it is, not what Dr. Singhvi's dictate.
May I say, this government servant deputation example.
Not only government servant, we are generalizing it.
Beyond that, I can't, in any case. Beyond that, I cannot say. I would not concede anything beyond that.
Suppose a judge.
Yes.
From Andhra Pradesh.
That will be
1 minute.
Government category.
We know that there are hard cases.
We will not.
No, just 1 minute. If a judge from Telangana is transferred to Bihar, his son has passed 10th in Bihar, and for no fault of the child, his father is transferred to Bihar and he passes 11th, 12th in Bihar, he will be deprived.
Well, it's at least 4 or 5 states, 3 of which are judgments. If the same person, what should be an example of, wanted to go to Haryana, Assam or Bihar, he'd be excluded.
Yes.
Across India.
Why don't you argue the merits? We are hearing you.
I'm answering a lot of query. I'm coming to merits straight away. This is on the merits, fellows. So I'm on the definition. Then, fellows, page 349 is the sub-rule deleted. Now, having seen this, come to 371D. I'm only arguing on the merits, fellows. 371D. This is where all this fellows concept comes of the Constitution, of course. 371D of the Constitution. Your Lordship has made special provisions, not for many states. Telangana is one of them, Your Lordship has made for 371D. Yes, after the bifurcation, of course, necessarily amended.
After that reorganization act. The bifurcation was done subsequent to the reorganization act of 2014.
Has to be. 371D, capital D. After that, the judgments. Keep judgments one by one. Will you leave it now? Get the judgment now. 371D. The President may, by order made with respect to the state of Andhra or the state of Telangana, in the matter of public employment and in the matter of education, and different provisions may be made for various parts of the state. Look at the width, fellows. 3 points. 1, specific to Andhra and Telangana. 2, education and public employment. Plucked out. There's a reason behind it. I mean,
What is the order passed by the President? What is the order passed by the President?
No, I'm saying, Maluk.
The President may. So the
Fortunately, we didn't expect it to go on in item 1.
he said that he wants to argue. Otherwise, we are.
Well, we were saying that last time I can hold your Lordship back. Take it to the end of the board, Wallace. We'll just collect all these things.
Otherwise, we'll pass an interim.
Judgments and all that, Wallace.
Otherwise, we'll pass an interim order.
This is the one. This is the one.
We had specifically kept. It is not as if that we are not put on notice. We had kept it at serial number 1 today.
Now, Wallace, the geo which I have in my hand is a precedent. Mr. Shravan Kumar, where are you?
You can open up some other screen.
Where is Mr. Shravan Kumar? Where is the judgment? What are you looking around for? Give another copy. Take the relevant portion. Extend.
Whether a similar order is also made for state of Telangana. What you are referring is for Andhra.
It applies by virtue of the act.
The act says that these things will apply mutatis mutandis to the bifurcated state. And whereas this is on para 4. Just see para 4. It applies to education institutions. Local area is para 3.
Local area.
Para 3. Yes. Then para 3.2 is the second set of local areas. Para 3.3 is the third set of local areas. So all of it is covered.
1 and 3 are part of Andhra now. 2 is Telangana.
The whole of this 2 is Telangana. Then let us come to 4. Local candidates. A candidate for admission to any course of study shall be regarded as a local candidate in relation to a local area if he has studied in an education institution or education institution such local area for a period of not less than 4 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying, where during the whole of the part of 4, so Malas, it is there, and Lordship will constantly keep the overall public interest intended bona fide. Your Lordship may Malas find some fault with the technical category, but the intention is very much from 371, a constitutional intent to focus on the state for education. That's the point I'm making. And today, Malas, we can file all the papers, but some of them may be here and there scattered. By the afternoon, it applies to both states.
Let us read the local candidates again.
Yes. Well, one thing before that, 3.2 is basically Telangana. You know, you've got those names, Adilabad, Medak.
This is Adilabad,
Medak, correct.
Attached to Usmania.
Yes. I'm grateful. Now come to local candidates. A candidate for admission to any course of study shall be regarded as a local candidate in relation to a local area if he has studied in an educational institution or education institution such local area for a period of not less than 4 consecutive academic years, ending, that is a typo, with the academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying exam, or where during the whole or any part of the 4 consecutive academic years ending with the academic year in which he appeared, or as the case may be, first appeared for the relevant qualifying, he has not studied in any education institution if he has resided in that local area for a period of not less than 4 years immediately preceding the date. So either study or reside. 2 tests. Now, Malads, Just let me go out of sequence a little bit. See three judgments, fellows, from different states. We got copies, and there's no copies available. Yeah. The problem is we don't have copies.
Just give it to others.
Keep the judgments ready now. What?
The act also will have to do with your one more copy, which is no ones. That's first. Comes in into the day.
What is the date of this? What is the date of this?
This is something, this 1st July 75. Just first.
Maybe this one.
1st July, here. No, it's
No.
July 1924.
It's not 74. It's not 74. Just bring it out.
It is 74.
No.
1st July,
Okay.
1971. It's published on 3rd July, right?
Right.
Now that situation continues for the Andhra Telangana.
This is what this dates about it.
Bifurcation complete.
May I? Sorry.
Bifurcation comes in. Andhra continues with this for themselves. Our kids can't go there. Their kids can come here. How does it work?
Andhra is not challenged.
No. Because the good colleges on das, yeah, Hyderabad. That's why nobody wants to do it over.
It's the projection of a constitutional purpose. It's not just in the air, mills. It's a promotion of a constitutional object.
Can they field all these years? From 74 to 2000?
Let's get the judgments organized. Pradeep, Anand, and all the other states, Haryana, Assam, get them organized with the paras. You can't find those things.
What is the date of this?
This is Malus, July 1st, 1974, published on 3rd July. That 74 is not given in the first line.
No, but this.
Under 371D.
Right. It's not with respect to
Malus, this is what is used in Andhra even today. Andhra students can come to me. I can't send to Andhra. Look at the irony. Andhra is doing this very reservation next door.
No, but is there any such presidential order?
Yes.
Post the Reorganization Act.
No, the section says, so just take this sheet, one pager here.
No, this is with regard to university.
This is regard to the overall undivided Andhra.
Undivided Andhra.
Yeah, now just see, take validity of this very article or basic structure was upheld by your lordships in Surekha. Now come to your lordship's query, which is actually 2 June 14. You should be right there. It's not 14. It's 2 June 14, which is given in the body. State of Telangana, Andhra was bifurcated on 2 June. Section 95 is the query my lord was asking us.
Yes.
Reads thus. Reads thus. My lord's got this sheet for us. Yeah. We have quoted it there. Equal opportunities for quality higher education to all students. In order to ensure equal opportunities for quality higher education to all students in the successor states, the existing admission quotas in all government or private aided or unaided institution of higher technical and medical education so far as it is provided under 371. So the Andhra Act recognizes 371. Shall continue as such for a period of 10 years during which the existing common. Now just pause here. A supreme irony I want to bring to your lordship's attention. Andhra continues with the very same reservation. My students can't go to Andhra. Andhra students can come here if your lordship strikes it down. And were coming here till I made this.
But whether it has been challenged in Andhra?
Well, it may not have been.
I
know for a man. No, true. That will be prospective now. A lordship will have the same law applying to the country, other states also.
In Assam and Haryana, it's been upheld.
This has been going on now for 10 years. After bifurcation, 10 years.
Come with this rule for the first time in 2024.
Yes.
It would have been a different matter if this 24 rule was to be given effect to from 28. Because now the students in 24 would know that they have to be consecutively studying in state of Telangana for a period of 4 years to be eligible to admission. But what happens to those students who are not aware about anything and they on a hope that they would get a better prospect in some 11th, 12th in some other institute, those to go to other state. And now they are neither here nor there.
When your lordship upheld 7 years, I read those judgments. That's all I can say. This has been upheld all India. This is going on for at least 4 or 5 states, upheld by my lords.
No. In Maharashtra also, my judgment, sitting with Justice Sandeep Mehta.
Yes.
Maharashtra also there is a domicile requirement.
Yes.
But domicile requirement doesn't mean that a person who has domicile but has gone for 11, 12 to other examination to other university. We can appreciate that this 24 rule.
Today, this case.
No, one minute. 24 rule being made applicable from 28 because the students would know from 24 onwards that unless they appear for 4 years consecutively.
Now my lord is raising a form of retrospectivity. What my lord is saying midstream.
How can those students be who are not aware?
Now 2 things. This applies only to Andhra. This Andhra people know for the last 10 years, from 74 of course the original, but from 2014, they know.
Section 95 has been there.
95 has been there.
They know that 10 years later it's going to end.
This was a
They know that the system which is available.
This provides 10 years.
The states knew it from 1970.
Just raise a different point. I'm on a different point. Let me finish that with the law. But answering my laws for a minute. Everybody in India knows from 1974, the President Directive. For the specific case of Andhra, and today's case will only concern Andhra, they know for 10 years that this cutoff will happen in 2024 or 24. They know that this benefit will end in 24.
Not 74.
No, because there was no Andhra and Telangana. No, I'm talking of for the whole country.
No.
74.
74, the local areas are defined by particular university. So the areas are divided into 3 universities. One for Telangana, then one university for certain districts of Andhra, then the third university for certain districts of Andhra again.
From 74, it will apply generally. No problem else. Now, a special thing happened for 2 states only in 2014, June. That was a bifurcation. Bifurcation told everybody in Andhra that you will continue to have the benefit of non-domiciliary. I'm using a word of my own words. Non-domicile.
So we are not saying that a person domiciled in Andhra would be entitled to Telangana.
That's what
we are only talking about the students who are domiciled in Telangana.
Yes.
But for A reason or B reason, they have gone to study 11th and 12th in the other state.
The bulk of the mischief sought to be addressed is students from Andhra. Not
yes, we are making it clear now. Mr. Shankar Narayan intercepted our order. We had made it clear that by an interim order, we are permitting only such of the students who are otherwise domicile of Telangana, but for some reasons have gone out of state of Telangana for completing their 11th and 12th.
But then, how will we apply 4 years? 4 years will go completely. 1 year, 2 years.
You apply from 2028.
Lordship dealt it in medical.
Mr. Suresh, we go.
Right.
Otherwise, you argue.
Right. Sorry.
Or you write the orders.
Right. Sorry.
When we are with you, why do you want to?
Right.
Just to show your presence, open your mouth.
Right.
So what my lord is now.
If you want to apply it from 28. But we will not permit such students who are totally caught unaware to be prejudiced.
What happened was, we tried to apply it in 23.
My lord.
If you are not, don't interrupt.
And why your lordship is already asking me so many questions, my learned friend. What
We will have to stop this virtual hearing.
I'm already having a tough time. Allow me to answer my lord first. Now, may I?
We are
in 23 we started.
We are, this rule is of 24.
No. Give me a background. 23 the proposal comes. They tell us that this 2014 will end in 24. You can't do it before 24. So we wait one more year.
Dr. Singhvi, we are making it clear that we are not coming to the rescue of the students who are domiciled in the state of Andhra Pradesh. We are very much making it clear that those students who are domiciled in Telangana or whose parents are domiciled in Telangana have completed their 10th or for some A reason, B reason, on account of their father's transfers were required to be out of Telangana.
Right.
And could not study for 4 years in Telangana. We are not opening a Pandora's box.
Your Lordship takes a call on the two remaining points. Two remaining points are 4 years and prospectivity on 28.
28, yes.
Broadly, my Lord is putting...
Yes, we can understand that in 24 you put everybody on notice that hereinafter you will have to complete 4 years in Telangana and therefore don't go out of Telangana if you want to appear.
Before your Lordship takes a call either way, just see the jurisprudence on this very briefly. Because otherwise, it's our duty to tell Lordship that point.
We'll consider the jurisprudence, but at times you also have to consider the ground reality.
No, Malas, your Lordship, Malas, ultimately, let me just place 2 or 3 contexts. It won't take long. Pradeep Jain, Malas, what is happening is the reality, your Lordship. One, I told you, Telugu diaspora. I don't think your Lordship wants to help them, Malas.
Let them come in NRA quota.
Second, 11, 12, you go to Dubai. You do courses there. Telugu is an affluent community. And you want to come back here and get admission here.
They are not aware that if I go to Dubai, I will not be entitled to. If his father...
They know from 2014 that this ends in 2024.
Forget about it.
They know from 2014 this benefit ends in 24. Look at the diaspora, you go and do very affluent studies there and you come back for here.
Maybe if the parents can afford, they will send him to 11, 12 or to Dubai or maybe to London or maybe to America.
No, but I am not grudging them that. That's very good. But then you can't reserve a place in my place, Malas.
But if they are otherwise in Telangana, their parents are residing in Telangana, they are domiciled in Telangana.
So, Malas, therefore, a narrow thing was sought to be plugged by the state in its wisdom. That we don't really want this for people who can afford to spend crores and study for 2 years there and come back here. 84, 3 SCC 654. 1984, 3 SCC 654. No copies?
Yes, sir. We have filed the compilation.
No, it will be faster for your Lordship's electronic to bring it up, Malas. Otherwise, we are a little disorganized today. The electronic system will bring it up to your Lordship's, Malas. We should have had copies of those.
We have books also here.
Books and your Lordship has it on the screen now.
No, we are more comfortable with the
Very
books.
good.
We are not so tech. At least I am not tech.
By the time I hunt around for my copies and all, well, there will be chaos. Take out 1984, please. 1984, please stop moving it around. 3 SCC 654. Let me take this.
654.
3 learned judges. At Malas, para. First turn to 1. Para 1. Get the next one ready. Anand. Keep it ready with you. I keep it ready. Nobody has any papers. Now, Malas, 1. This group of writs raised a great question of national importance.
One minute here.
Oh, I'm sorry. Oh, book is being brought. Quickly now, quickly. Just get 2 copies, sir. Same as the SCR there. You'll end up having SCR. You just follow it. I want to mark it. Use this. This Pradeep Jain is number 5. At page 124 of this book, we've got the photocopy just now. May I read para 1 at page SCC page 660. My lord has got it?
Yes.
Group of writs raise a question of great national importance affecting admissions to medical colleges both at undergrad and postgrad level. The question is whether consistently with the constitutional values, admissions to a medical college or any other institution of higher learning situated in a state can be confined to those who have their domicile within the state or who are resident within the state for a specified number of years, or can any reservation in admission be made for them so as to give them precedence over those who do not possess domicile or residential qualifications within the state irrespective of merit? This question has assumed considerable significance in the present day context because we find that today the integrity of the nation is threatened by divisive forces of regionalism, linguism, communalism. Regional, linguistic and communal loyalties are gaining ascendancy in national life and seeking to tear apart and destroy the national integrity. All lines are arbitrary. Constitution bench. We tend to forget that India is one nation and we are all nations first, Indians first and Indians last. Can we remind ourselves the great history of visionary Jawaharlal Nehru, who said, who dies if India lives, who lives if India dies? We must realize, and this is unfortunate, that many in public life tend to overlook sometimes out of ignorance, etc. Now let us come to para 16. 39. Will you stop this, please? Stop doing what I'm doing.
26.
Now, para 13 is on equality, a paragraph which was just see some parts of 13, fourth line. Now, the concept of equality under the concept of dynamic concept takes in sweep every process of equalization and protective discrimination. Equality must not remain mere idle incantation, must become a living reality in a hierarchical society with an indelible feudal stamp and incurable actual inequality. It is absurd to suggest that progressive measures to eliminate group disabilities and promote collective equality are antagonistic to equality on the ground that every individual is entitled to equality of opportunity based purely on merit, judged by the marks obtained by him. We cannot countenance such a suggestion, for to do so would make the equality clause sterile and perpetuate existing inequalities. Equality of opportunity is not simply a matter of legal equality. Its existence depends not merely on the absence of disabilities. Where therefore there is inequality, in fact, legal equality always tends to accentuate it. What the famous poet Blake said, one law for the lion and the ox is oppression. It could be a lamb also. Those who are unequal, in fact, cannot be treated by identical standards. That may be equality in law, certainly not be real equality. It is therefore necessary to take into account de facto inequalities which exist in society. Take affirmative action by way of giving preference to the socially and economically disadvantaged persons or inflicting handicaps on those more advantageously placed. Such affirmative action through apparently discriminatory, though apparently discriminatory, is calculated to produce equality on a broader basis by eliminating de facto inequalities and placing the weaker sections on a footing of equality with the stronger and more powerful sections, so that each member of the community, whatever is his birth, occupation or social position, may enjoy equal opportunity of using to the full his natural endowments of physique, etc. Then Xavier's is quoted. I will skip that and come to para 16. One line in para 14, then 16. Come to the last line of para 14, just above 15. Yes. Does my Lord have para 15? 5 lines above para 15? Honorable Chief Justice has, Justice Chandran has.
Yes.
5 lines above 15. This justification of the discrimination based on residence obviously rests on the assumption that those who were bona fide residents of Madhya Bharat would, after becoming doctors, settle down and serve the needs of the people in the state. We are not sure when any facts were pleaded in the affidavit justifying this assumption, but the judgment of Justice Iyer shows that the decision of the majority proceeded on this assumption, and that was regarded as a valid ground justifying the discrimination made in the impugned rule. Then after minor Rajendran, come to 16, para after the next. This court also upheld reservation based on residence requirement for a period of not less than 10 years. Let us kindly bear with me. Let us kindly see this. At least the state's intent is bona fide. And Malas, we can always do some minor corrections here and there, but please, Malas, kindly consider not disturbing something in the state's interest of those who are there. Kindly see the larger picture. 10 years for admission to medical colleges in Mysore. In the subsequent decision in Vasundhara, the rule which was impugned in that case was Rule 3 for selection of candidates for admission to the professional course leading to MBBS in the government medical college in the then state of Mysore. This rule provided, quote, no person who is not a citizen of India, that is one category, and who is not domiciled and resident in the state of Mysore for not less than 10 years at any time prior to the date of application. Let's please see. The petitioner's application for admission rejected on the ground that she had not resided for a period of 10 years as required by Rule 3, and she consequently challenged the constitutional validity of the rule on the plea that it violated the right to equality. Take out citation when I ask you something, do it. Write on a piece of paper and take out that para. all lines are arbitrary and necessarily all cutoffs are arbitrary. Take it out. The challenge was, however, negative, and the constitutional validity of Rule 3 was upheld. DP Joshi Malas, I will not read it to save time, is the single most important case. Your Lordship, Malas, take it as read. It is quoted. The relevant thing is italicized. Well, I hope I am clear. DP Joshi, Your Lordship, may
impart medical education to the best talent available out of the class of persons who are likely, so far as it can reasonably be foreseen, to serve as doctors, the inhabitants of the state.
Exactly.
So therefore, a person who is residing in the state of Telangana from his birth till the age of 16 years, he passes his 10th in Telangana, and for a gap of 2 years, so as to compete in NEET, goes to Dubai, America, or Mumbai, Delhi, would he be thrown out? His parents are residing there. He plans to set up a big hospital with his father's riches.
Well, as the person who gets it is also Telangana domiciliary. The person who will get it in his place in your Lordship's example.
Maybe, yes, maybe.
And well, just give me a minute. That person.
So therefore, we can understand if you put on notice to the students from 24, now after you have to be here continuously for 4 years, don't go to Dubai, don't go to US.
No, may I say, let this start. Well, let me now meet this point frontally. My Lord has put this to me more than once. It is also public policy that the person who can go abroad, your Lordship talks of US or Dubai or any other place, he doesn't necessarily deserve to come back. He can afford, he has many more opportunities. His opportunities and his avenues are many more. The man who's there, Malad, is to be accommodated.
Everybody doesn't go to Dubai. Everybody, some of them might have gone to Kota, some of them might have gone to Latur.
No, Malad, I'm only using the words, Malad, which are just used. I'm giving examples. Malad, there may be a government policy that, look, those who are there, who can't even afford quota. Quota is pretty expensive, Lordship knows, Malad. Quota is pretty expensive. Now, Malad, I am giving a Lordship a Mysore 10-year example. Your Lordship will either say that the concept of domicile is bad.
So in Mysore, they did not state immediately preceding the qualifying examination.
Malus, that may be, Malus. 10 years will cover everything, Malus. Immediately preceding or much before also.
No.
It will cover everything.
It would cover a case.
10 years.
It would not cover a case of a person who had resided there for 10 years, but for a short period of 2 years has gone out for doing 11, 12.
It is that, because the Rule 3 in that case says no person who is not a citizen of India and who is not domiciled and resident in the state of Mysore for not less than 10 years at any time prior to the date of application for
so then is it not a wider thing? See, you restrict it to the immediate 4 years after qualifying examination.
Yes.
10 years means at any time, if he has been studying 10 years, he will be entitled. That is what this rule says.
No, the rule is very different. Rule is here.
Prior to the date of application.
It says 10 years.
Any time.
It distinguishes who is not domiciled.
No, it doesn't say
and
that.
who is not resident.
But immediately 7 years.
So, but it distinguishes a domicile and a resident. 1 minute. We also have we have a right to make a query. If you have your permission, we may ask. So it distinguishes either a person who is domiciled in the state of Mysore or a person who is resident of Mysore for 10 years.
So
there's a distinction between a person who is domiciled, who is a domicile of Telangana. There might be a certificate, so and so is domicile of Telangana. Like we have a certificate in a domicile of Maharashtra, I still have that certificate.
Yes.
So even if I live in Delhi, I am domiciled in.
See, Mr.
Before your
Director,
Lordship gave a Delhi wala, that certificate.
This was the rule in your case. In your rule, it mandates that the qualifying examination should be from Telangana. If this were the rule, the person who has completed up to 10th standard in Telangana and who goes out for 11, 12 would be entitled, because any time prior to test. So this is wider. Don't rely on this.
We will cite another case.
Anyway, you complete the law.
Yes.
Say that.
Sustained by your Lordship.
So, Manas, so now para 17 continues, Manas, with another case, Chanchala's case. I am saying, Malus, two things as I leave this case. I'm coming to the second case now. Please bifurcate conceptually. Issue 1 is domiciliary per se pernicious, contrary to all India being one. Answer is clearly in judgment after judgment, no. 2, does 371D makes domicile or education, etc. preferences clearly acceptable? Answer, yes. Then all that remains is the actual nitty-gritty of 4 years. And now my lord has found, Malus, here this point about consecutive years. Now, Malus, first of all, 10 years is 2.5 times 4 years. It will cover most.
Not the consecutive. We are talking about the 4 years ending with the qualifying year.
Now, I will cite a judgment of application ending with that of 7 years. That also I'll cite. So this is one case, Malus. Come to the second case, which is Anant. Give it, please. Give it. Which is in
Serial number 1.
Yes.
Serial number 1.
In this serial number 1, and the relevant paras are
3, 4, and 8.
3 onwards, Malus, 3, 4, and possibly 8. Give me the. I'll use this. You got it here? Let's just follow this here. 3, Malus. Does my lord have that thing, Malus? The first serial number. Case in the first serial number. Anant. Para 3. This is Haryana now. We are talking of Haryana. As my lord, the Honorable Chief Justice, have 3, Malus, para 3.
This is for 10th, 11th, 12th. All 3 they need to have this.
May I read 3, Malus?
Yes.
I'm reading para 3 at page 3. This is Haryana. Till 1993, the eligibility conditions required inter alia that a candidate to be.
Yes, yes.
Till 93, the eligibility conditions required that a candidate should be a resident domiciled in the state of Haryana and was required to produce a certificate of Haryana domicile residence as prescribed in the rules. In 94, the eligibility conditions were changed. The relevant paras of the 94 are as follows. 1. The candidate who has studied 10, 10+1 and 10+2 classes regular candidate recognized institutions in Haryana. Children wards of the employees appointed on regular basis of Haryana government, members of All India Service, born on Haryana cadre, established by under an Act of Haryana. Children wards of employees of Indian Defence Services belonging to Haryana, etc.
10th, 11th, 12th. All three are
Just
required.
underline and double tick the first one, Malus. 10, 10+2 and 10+1 and 10+2.
11th, 12th. All 3 are
So all 11, 12th, 10th, 11th, 12th are all covered. Thereafter, a corrigendum was issued by the state of Haryana, granting eligibility to children of the employees belonging to Haryana.
No, for them, 10th, comma,
11th.
10+1, comma, 11th, and 10+2.
Well, it's not or, well, it would be
No,
all.
then it's comma.
No, comma and, well, it's comma, and. It's all clubbed, well, it's all 3. The challenge was exactly on that point. May I read, well, I understand my lord's query. The challenge on that point.
Read para 4.
Now, well, the first 3, let us finish 3. Thereafter, a corrigendum was issued. Forget the corrigendum is not relevant to our case. Come to 4. The petitioners before the Punjab and Haryana High Court had challenged the eligibility conditions of 94 insofar as they required the candidate should have studied. Now, this is my lord's query, Malus. Just will note this, the third line. Should have studied for the 10th, 11th, and 12th standards as regular candidates in recognized institution Haryana. They also challenged the corrigendum. The 2 learned judges of PNH who heard these writs differed. Hence, the petitions were referred to a 3rd judge who concurred with one of the judges and held that the condition requiring a candidate to have studied in 10th, 11th, and 12th in recognized institution in Haryana was valid. The condition of the corrigendum, which required an affidavit from the parent or guardian of the candidate not appearing or had not appeared in the entrance test of any state union, was, however, struck down as arbitrary. So this is clearly the middle of para 4 is the exact question my lords asked me. Now come to Malus para 7. 8. In view of the above facts, may I read?
Yes.
We have to consider whether the condition requiring a candidate to have studied in 10th, 11th, and 12th in a recognized institutional state of Haryana can be considered as arbitrary or unreasonable. It is by now well settled that preference in admission on the basis of residence as well as institutional preference is permissible, so long as there is no total reservation on the basis of residential institutional preference. D.P. Joshi, my lord, the seminal case cited again here. Now come to the third case of Assam. It's not, Malas, that simple. They are trying to make it as a malafide kind of thing. Malas, we have done it bona fide after studying the law. Malas, remember Nakara, Malas. 3 years will be as bad, 5 years will be as good. I've chosen 4 years. Nobody can choose except the state. Courts can't choose that 4 years for me, Malas. This was Haryana was a 7-year case. Sorry. No, sorry. Assam is 7, Haryana was 3 years. Your lordships can't, Malas, judge on that line. Now come to Haryana, Assam. Kumari Chitra Ghosh, which is the item? No. Rajdeep Ghosh. 1 minute. 1 minute. 1 minute. Does the compilation have it?
Page 9 in the compilation.
Page 9 in the compilation. Give me the correct. Yes, what are you? Page 9 in the compilation. In your lordship's bunch. 2018, 17 SCC 524. Now, Malas, para 2 first, after a fairly long head note, it starts at page 15 of the compilation. And para 2, Malas, reads thus: the following, this is my Lord Hammer's page 16, para 2.